Good morning, everyone. My name's Michael. I'm a partner here at the employment team at VWV, and I'm doing this webinar with my colleague Alice, also a partner, as you can see. And we're going to cover some topics which hopefully pop up on the next slide. I'll speak to you first about the decision in Azdor and Tesco, and then I'll talk a little bit about re-engagement in the Jones and JP Morgan case. And then Alice is going to talk to you about the effect of contributory conduct in the Wilkinson and Vehicle Standards Agency case, and a little bit about gender pay gap reporting and moving away from mandatory vaccinations. And at the end, we'll have questions which we can pick up out of the chat box. So looking first at the actually, first off, nearly forgot, we have a question which would be great if you could put an answer to. Have you used termination and re-engagement in order to introduce changes to staff terms and conditions? I think there should be a yes or no option, and we'll give it a few seconds to allow some responses to come in for that. Okay, so thank you very much for everyone to come back on that. There's been quite a number of responses, and I would say that they split very broadly into 2/3 no and 1/3 yes. So that's quite an interesting thing. Obviously, it's something which is not uncommon, but perhaps that indicates that it's something that people are quite wary of adopting. And I think that's quite a good illustration for the Tesco case, actually, that we're going to go on and talk about now. I just have to look at that. So the slide is hire and refire. Traditionally, we refer to it as dismissal and re-engagement, but I think fire and rehire is now the terminology used in the press and by the government. So a little bit of context first about what it is. So as an employer, if you're looking to change terms and conditions of employment for your workforce or for a part of your workforce, you'll enter into a process of consultation with them probably, and hopefully reach agreement with the employees, and they will sign up to the new terms and conditions and everyone will move on. But a problem arises for employers where the employees will not sign up to terms and conditions, to the new terms and conditions. And then traditionally, there are two main alternatives available to the employer. The one is impose the terms of the new terms unilaterally, and that comes with quite a number of risks attached to it and has to be looked at very cautiously. And the second one is to serve notice to terminate the old contracts and at the same time offer those employees re-engagement under the new terms and conditions. And historically, that's been seen as often the safer option of the two. So it's been in the news a lot recently, fire and rehire, and I think that's mainly because during the pandemic, employees and trade unions, I think, felt that during times of uncertainty, employers were jumping too readily to threaten or propose fire and rehire type situations. So alternative terms and conditions are being offered, and if there was resistance to signing up to those new terms and conditions, perhaps because they were less favourable than the old, the perception was from unions and employees that employers were jumping very quickly to threaten dismissal and re-engagement or fire and rehire. So that led to quite a number of high-profile disputes over the last couple of years, and Tesco is one of those that we'll come on to look at. It's also generated new guidance from ACAS, and it has led to pressure on the government to intervene to make firing and rehiring unlawful, and we'll look at how far that got as well. So looking now at the Tesco case itself, it's brought by Azdor, which is a trade union in that case, and in 2007 or 8, Tesco is going through a process of restructuring and relocating its distribution warehouses And this puts a number of employees at risk of redundancy. At the time, in order to avoid redundancy, there was the possibility of relocating, often to quite different parts of the country, which is difficult for all employees to do. So in conjunction with Azdor, the union involved at the time, Tesco came up with a retained pay scheme, which gave an enhancement to pay, often quite a big one, in return for the employees relocating and avoiding redundancy. When they were going through that process, there were several references to the retained pay element being guaranteed for life and being a permanent feature of collective agreements and expressly incorporated into individual terms and conditions. And it was stated on several occasions that the only way to change that position would be through agreement with the employees themselves, or if the employees took up alternative work. And it was very clearly trailed as a permanent feature of everyone's terms and conditions going forward, as long as they remained in the same job. So 10 years later, in 2021, Tesco decided that it wished to remove the retained pay element, which it had promised was guaranteed for life 10 years earlier. And it entered into consultation to do that. And it made clear that employees who were unwilling to sign up to the new terms and conditions would be dismissed and re-engaged on the new terms and conditions. Now, Tesco were offering an inducement of, I think, 18 months pay or something in order to sign up to it. But nevertheless, they were removing what they previously promised was guaranteed for life. In response to this, Azdor went to the High Court and asked for two things. One was a declaration that there was an implied term that Tesco couldn't terminate the contracts in order to avoid paying the retained pay element. And the second one was an injunction to prevent them continuing with the consultation process they were in. And both of those things were successful. So Tesco were prevented from going down the route of terminating and re-engaging or firing and rehiring in order to avoid paying the retained pay element. During the course of the judgment, High Court looked at what permanent meant, and they accepted that in normal course of events, permanent would mean as long as someone's contract was continuing. But in this case, given all of the promises that were made during the process back in 2007 and 2008, they felt that Tesco had gone further, and on that basis, they were prepared to find in favour of the union, imply a term into the contracts, and issue an injunction. What they did say, however, is that they weren't interfering with Tesco's underlying right to dismiss employees and offer re-engagement in other circumstances. So, for example, in cases of redundancy or gross misconduct or anything like that. So the court was quite careful to intervene, but in a targeted way in respect of the retained pay element. So looking at the case in general, I mean, they are quite quirky set of facts. And when you look at it, the promises made by Tesco are actually pretty strong. And it's unlikely that those perhaps would be made by many employers in similar circumstances. However, I think there's an immediate direct lesson, which is that if you're offering inducements for people to sign up to new terms and conditions, you need to be careful about the language you use when you're going through that. Perhaps more widely, the case is an indication of the fact that fire and rehire in the public perception has fallen out of favour in many ways, and that will come under greater scrutiny in the courts and tribunals in the future, and that courts and tribunals might be more willing to intervene than they used to be. In this case, they issued an injunction. So where are we now in respect of fire and rehire? Well, it's clear that if you adopt the tactic, there will be some reputational risks, I think, given the public perception of it at the moment. And ACAS's new guidelines make it clear that fire and rehire is an extreme step. However, it is still for the majority of employers, still a legitimate and lawful method of implementing change if agreement is not possible. And the key thing, I think, that you take away from Tesco and from the discussion today is that if you're going to use it, you need to just use it in the right way. And there are just a couple of quick points I'm going to make about that. The first is to make sure that you have a good business reason requiring change. Second is to treat the option of dismissal and re-engagement very much as a last resort. The third is, before you consider informing the employees of dismissal and re-engagement, make sure you go through a full and thorough consultation process. And part of that means using all reasonable attempts to reach agreement with the employees. And that means keeping dialogue open and constructive and making use of the new ACAS guidelines and being able to demonstrate that you've considered those ACAS guidelines and implemented them where possible. Actually, I read them yesterday and they are very helpful at providing common sense pointers about how to reach agreement with people without having to take the final step of dismissal and re-engagement. Fine, so now I'm going to move on to the next case. I think we might need to turn the slides on to JP Morgan, that's right. So this is about re-engagement, but it's about the Employment Tribunal's power to order re-engagement as a remedy for unfair dismissal. So it's not what we were discussing in the case of Tesco. So tribunals, if they find someone's been unfairly dismissed, they can order either reinstatement or re-engagement. Reinstatement is where someone's put back into the same position they were in before, and re-engagement is when they're put into a suitable alternative employment with the same employer. Now, it is a very rarely used power, and I think there are obvious reasons for that, that if someone has been dismissed, for whatever the reason for that, the idea that everyone will just get along and carry on again as if nothing had happened may be a little bit unrealistic. So it is a very rare order to be made. And the case of JP Morgan is a rare example of it happening. And this case in the financial sector. So looking through the facts generally, there was an alleged spoofing incident in 2016 involving Mr. Jones. And I am no expert, but I understand that spoofing is where a trader prepares to make a trade, and obviously there's things you put into the system or whatever, but just before the trade is executed, it's cancelled. And the purpose of that is to generate interest or manipulate the price of whatever it is that's being purchased by making false suggestions of the demand. Anyway, it's an unlawful act, and I think the regulator says it's expressly unlawful. However, back in 2016, when JP Morgan looked into it, they didn't find that Mr. Jones had done anything wrong, and they took no disciplinary action at all. And then everyone moved on. But in 2019, the financial regulator became more interested in the topic, and JP Morgan created a new policy. And as a result of that, it started revisiting past investigations, and it revisited the investigation of Mr. Jones. And on this occasion, there was a fairly short process, and Mr. Jones was dismissed for gross misconduct in 2020. So looking at the next slide, the tribunal held that his dismissal was unfair procedurally, and we don't really need to go into that too much. But interestingly, I think it held that one of the interesting things it found was that the bank itself didn't really believe that Mr. Jones had done something wrong. What it was trying to do by dismissing him was appease its own regulator, the financial regulator. The tribunal also found that the bank didn't really believe that Mr. Jones had done anything wrong. However, despite this, its intention to appease its regulator, it was refusing to provide Mr. Jones with a suitable reference. And in the financial world, in certain roles, you need to be declared a fit and proper person. And JP Morgan was saying that it wouldn't offer a reference which said that Mr. Jones was a fit and proper person. Now, the effect of that was that Mr. Jones was looking at career-long losses, unable to work in the industry he was capable of working in because of the lack of a potential lack of regulatory recognition. So Mr. Jones asked for an order of re-engagement or reinstatement. Reinstatement wasn't possible because the team he worked in had moved on. There'd been a series of redundancies and restructuring. However, he was clever enough to find alternative suitable work in Hong Kong for JP Morgan. And the tribunal ordered that he should be re-engaged in that work in Hong Kong and accepted that it was appropriate and reasonable. And you'll see there's an enormous figure there of £1.5 million in loss being awarded to Mr. Jones. And that's because if you are successful in obtaining a re-engagement order, the tribunal will commonly award you your lost salary between the point of dismissal and the point of re-engagement. And unlike normal unfair dismissal awards, there is no cap to that element of the award. So obviously he was a large earner. Between 2020 and 2021 or 2, when this judgment was made, he had around £1.5 million of financial loss, which is quite considerable, and obviously makes these sort of cases hit the headlines. I think the takeaway from that is that particularly in regulatory environments, particularly where there is a question of career-long loss, and particularly where the tribunal has found that there's been a real injustice, there will be perhaps the tribunals will be more open to look around to try and find ways of remedying that injustice. And in this case, there was, through Mr. Jones's sort of entrepreneurial look at it, there was a way to do that by ordering a re-engagement in the Hong Kong role. Okay, so now I'm going to hand things over to Alice, hopefully, who will look at the next slide with you.
Thanks ever so much, Michael. Yes, I've got one case that we thought would be interesting to share, and then a couple of just updates to get on your radar. The case that I'm picking up on is Wilkinson and Driver and Vehicle Standards Agency, which is a recent EAT case. And there are a couple of useful threads, I think, that come out of this when considering how to approach a disciplinary process. Mr. Wilkinson was a driving examiner and had been employed since 2016. But it all went wrong in 2018 when essentially he was undertaking a test, it finished early, and he drove the candidate's vehicle back to the test centre. That was strictly in breach of the DVSA's policy, which he was aware of because there was no insurance cover in place. Not only did he get that wrong, but actually then he attempted to cover it up by not mentioning it to his line manager, and they had to complete a report about the test and the fact that it had finished early, and he didn't mention again that he'd driven the candidate's car. So the employer investigated, and he was then dismissed for gross misconduct. He brought a claim for and the basis for his dismissal was twofold. It was his gross misconduct and that there'd been a breakdown of trust and confidence. And it took into account that one of his senior managers had emailed the investigating officer saying that he felt that the trust was broken and that it was hard to repair. So it went to Employment Tribunal, and the next slide's just got the findings of the tribunal. So the tribunal found he was successful in his unfair dismissal claim, and the reason for that was that the process was flawed. So the email that was relied on in relation to the breakdown of trust and confidence wasn't part of the pack, so he didn't have that ahead of the hearing. The letter setting out the allegations and what was going to be considered at the disciplinary hearing also focused entirely on conduct, but didn't talk about whether there'd been a breakdown in trust in confidence. So it was found that the process overall was unfair, and so he got his declaration that he'd been unfairly dismissed. However, the tribunal then sort of tied themselves in knots and found that they thought that if he had had sight of that email and if he had understood the nature of the allegations properly, he still would have been dismissed in any event, and so they reduced his compensation to 0. Mr. Wilkinson appealed, and he was successful in his appeal, although I'm not sure that it's going to pay off, really. He said that it wasn't right that his compensation should be reduced to 0 in these circumstances, and that the Employment Tribunal hadn't considered that properly. Well, the EAT agreed, but what they found is a useful refresher, really, in terms of how tribunals do approach compensation. And so if you're on the wrong, or we hope to avoid litigation at all, but if you're on the wrong side of a claim, or if you're hearing an appeal when you know things have gone awry earlier on in the process, which sadly does happen from time to time, it's useful to think about it in these terms. There are 2 separate tests and ways that compensation can be reduced. So the broad principle is that an employment tribunal can make an award based on someone's actual financial losses, but it can be reduced based on their contributory conduct, and that should have been engaged in this case. And in that instance, a tribunal can apply a percentage reduction to the extent that the employee is culpable for the decision, for the reason for dismissal. So actually, he was quite significantly culpable here. He'd got something wrong in the first place, and then he'd covered it up. So it wouldn't be unreasonable for the tribunal to significantly reduce the amount of compensation. However, the tribunal needed to consider that appropriately and also take into account any contributory conduct by the employer, so balancing the things the employer had got wrong with the things the employee had got wrong when assessing the reduction in compensation. Quite separate to that is what the tribunal tried to do, which is also valid, which is what's known as a Pulkey Reduction. Some of you may have heard of that, which is if there's a procedural flaw, what is the argument that if that procedural flaw hadn't happened, the dismissal would have happened in any event? And that's what they tried to consider. And that's relevant too. So in this case, they could have considered both grounds. Instead, they sort of conflated them and got the legal test wrong. So it's got sent back to the tribunal. I'm not sure Mr. Wilkinson's going to get much money, despite having probably spent a lot going through both the tribunal and the EAT hearing. But any tribunal has got to consider how much compensation he should get, taking into account both those legal tests, but ensuring, of course, that there's sort of no double counting. So we'll see. We'll see what happens, or more likely, they might settle for some small sum of money beforehand. So there are some useful things to take out of that. First of all, the importance of getting the process right. I mean, this is a really frustrating case for any HR practitioners and employment lawyers, because it's one of those that you get that should never have gone wrong. And it's just the importance of, he's clearly got things badly wrong. There's clearly an express breach of a policy that he knew about. So framing discipline, the importance of getting the investigation carried out correctly, but also framing those disciplinary allegations and actually taking some time to reflect and think, what case do we actually want to put to this employee, and what evidence is there that we're relying on to support that case? And we often see employers rushing to get out disciplinary invite letters, and they're often based on sort of standard pro formas that you've got in the bank, which we all use as a starting point, of course. But actually, it's really important taking some time to get that right. And once you've got that right, it enables the panel or whoever's considering the disciplinary, to assess each of those allegations properly, consider the evidence, and allow the employee, of course, to respond to those, knowing that that's the basis on which a decision will be made. So it's really important to approach it in that way. If things do go wrong there, as I say, and you're considering how to resolve a case, either at appeal or on a run up to a tribunal, definitely think about contributory conduct, and those Pulkey would have been dismissed in any event, procedural flaw arguments, in order to improve your negotiating position. So that's the end of the case roundup, but there are a couple of other things that we thought that have happened that we thought would be useful to share. So the first one I wanted to mention is just a heads up around what's going on with gender pay gap reporting. Before I get to talking, there's another question for you to ask. It's an opinion. It's a loaded opinion, perhaps. Do you think that the pay gap reporting requirements should be extended to look at other gaps such as disability and race? If you could give me a yes or a no. Ooh, that's interesting. I think most people replied to that. So the vast majority in there were yes, notwithstanding the work that it would entail. Well, it's probably good news then that is more likely than not to happen, I think, again, for those organisations with 250 or more staff in the first instance. We can just flick on to the next slide, which is the update one, to just pick up some of the things to be aware of. Really, it's just a reminder that we're back around again to the snapshot date to capture the data, but also to then report on last year's data. Of course, because of COVID, we saw a 6-month extension last year, so it's come around again incredibly quickly. So just to make sure that you're on top of that. And the dates, I know we have got some public sector organisations on the list. It's the 30th of March and 4th of April for private sector employers to do the gender pay gap reporting, where you've got more than 250 staff. It is 5 years now since we've had the gender pay reporting legislation. Don't know where the time goes. And so the government had committed to reviewing that to consider whether it was still meeting its objectives and whether it was effective, and whether the balance was right in terms of the burden on employers. So that review is taking place shortly, and if there are any changes, we'll obviously let you know. The indications are that we're not going to see any significant changes to the way in which the gender pay reporting is working, but the loaded question, that it is still mooted that we will see an extension to the pay gap reporting regime to cover ethnicity, and also there's a current consultation that's due to close shortly in relation to extension for disability pay gaps. And the rationale is that actually you need to look at all of the factors, and sometimes it's a combination of factors that has the most significant impact. So I think that it will be on its way. So it's just worth thinking about what data you're currently collecting. I wouldn't recommend you necessarily launch ahead. Although some organisations, of course, we've seen some voluntarily reporting, particularly ethnicity data gaps as well. I also wanted to just flag up the sort of work that we're doing and talking to clients around. Obviously, everybody's had a lot of competing priorities, and it's been an incredibly busy and challenging couple of years. But actually, it is noteworthy that we're now 5 years into the gender pay gap reporting. And so some of those patterns will have begun to develop, and actually, you know, you probably wouldn't have necessarily understood what was happening in year 1, year 2, but now at year 5, you should be able to see and have a better feel for what's happening with the data, and particularly whether you've managed to close the gap or whether it's expanded. And actually, look at what steps you're taking to tackle that. And that links in, I suppose, in many ways with some of the other changes that we're seeing around. Obviously, colleagues have talked about the flexible working regime being extended and a real push on flexible working, which is intended to help reduce the pay gap. And there was an interesting consultation just recently, which said not only does that need to tackle enabling senior females to work flexibly so it doesn't act as a barrier on their career progression, but also we should be talking about a culture where male carers are able to work flexibly as well, and that needs to be tackled so that we've got broad equality, and that should help close the gender pay gap. So it's definitely worth taking some time to look at your data and what you can do to reduce the gap if you've got one. And my final slide that we just wanted to flag by way of update is that since the last session a fortnight ago, we have now seen regulations come into play which are revoking the mandatory vaccination regime in the health and social care sectors. So that they came into force yesterday. So this will only affect some of you, but it's probably of interest. You may be aware that we saw mandatory vaccinations in the care sector. And so any of you who are involved in that had to go through procedures to require all your staff to be vaccinated. And we saw a number of dismissals in the care sector as a result of staff refusing to be vaccinated where there was no redeployment option in play. We then saw proposals to extend the mandatory vaccination regime into the wider social care and health sectors, but all of those requirements have now been revoked. It has been quite contentious, and there's generally sort of dissatisfaction around it. So I suppose it will be interesting to see. It links into us moving from, COVID restrictions to living with COVID, and how that works is something that's going to be a transition. As you know, at the moment, we've seen an end to self-isolation on the 24th of February in most sectors, but some close care still has that, and obviously we're seeing a move away from that. So employers are tackling their policies to think about how they can ensure a safe place of work. That's all that we've got to say, all the update topics. I hope they were useful. We can now pick up a couple of the questions. We've got a couple in the box. If anybody's got any more, please do put them in the Q&A. So the first question is, it may seem like a basic question, I don't think there's any such thing, but is the fire in Fire and Rehire considered to be a legally fair reason for terminating an employee's employment? Michael, do you want to pick up that one?
Sure. So it is a good question, and I don't think it's concentrating on the fire in the Fire and Rehire, which is the key, but looking behind at the reason. For employees with more than 2 years employment, you still have to have a fair reason for dismissal, even if you're going through a Fire and Rehire process. So what that reason is may vary depending on the circumstances. So you might be going into change terms and conditions because there's a general sort of redundancy type issue, in which case the reason for dismissal might be redundancy potentially. And obviously you'd need to have gone through a fair process for that and make the necessary payments. Otherwise, if it's more of a business reorganization and the definition of redundancy is not satisfied, then it's likely to fall into the some other substantial reason type category. And that's why it's so important to have a good business reason for the change behind it, because when looking at some other substantial reason, the tribunal will effectively carry out a balancing exercise, looking at the detriments to the employee, the obvious ones in many cases, and the need for the employer to go through that process and balance those up, as well as looking at the process in general for fairness, so full and thorough consultation, etc. Alice, have you anything to add to that?
No, that's perfect. Thanks, Michael. The second question is harder because it's a data protection question. So, Michael, I will fumble my way through it, but if you can add anything, you can help. But it's actually, how do you monitor race, disability, etc., in view of GDPR considerations? And so the principles, I think that's the question. The principles really around, well, first of all, if things are anonymous, they may or may not be personal data if an individual's not identifiable from that. So often that will be the case. Obviously, sometimes organisationally, you will be able to identify individuals, for example, if you want to capture their job roles or how recently they've joined the organisation and some other factors as well, in order to do that, or then it may fall within the scope of personal data and be covered by the data protection principles and the GDPR. And the basic principles are that you need to ensure that staff understand what data you're collecting and what you're going to do with it. So you've got to be transparent. So you need to be really explicit in your privacy notices around that. You then need to process it in a fair manner. So you need to make sure who has access to it and how long is it retained. And make sure it's kept secure, and those principles. And then you need to make sure that the reason that you're collecting it and processing in that way falls within one of the legitimate reasons to process data under the data protection legislation. So if you're doing it to comply with a legal obligation, obviously if we see the legislation, that is straightforward. But I would anticipate that trying to address equality issues in the workplace and deliver positive equality benefits under the Equality Act is likely to fall within one of the categories that allows you to process that data. So, sorry, that was a bit rambly, but essentially, I think that that if you are going to do it, there are considerations, and you probably should take some specific advice, but you're likely to be able to do it as long as you go through the different steps and are really clear about it with your staff and have the security measures in place. Michael, is there anything you think I've got wrong or you want to add to that?
Well, I was going to add, and someone's put another question in actually about how accurate can the reporting be if it's voluntary, or should it be mandatory to get disability or race information? I mean, I agree with absolutely what you said. And I was just wondering, I can't see a position where people will be forced to give up details of their ethnicity or any disability. So you will be relying on voluntary disclosed information. And we don't know how it'll work in practice, but I am guessing that it will take account of the fact that data is provided voluntarily, and the employers will declare on the basis of voluntary data. There might be an obligation on you to facilitate the collection of the data, but there can't be one forcing you to get that information or to guess about people's ethnicity or disability.
No, I agree entirely. Obviously, we don't really know, but it is. But even employers who gather ethnicity and other monitoring data currently do so on the basis that it's an entirely voluntary process. I think that's always got to be the case, hasn't it? Really, but I think as an organisation, you would want to put in reasonable steps to reassure people. For example, is it going to be kept anonymous, and how will it be used? And so hope that you can overcome as many objections as possible to encourage wide participation. But yeah, as you say, it will be entirely voluntary.